or my lord, something more to add, my lord. Adopt what the learned senior has said. Lord, the subject your lordships are dealing with virtually, my lord, creation of a socio-legal system, socio-legal relationship of marriage, which, my lord, I'll come to, my lord, my preliminary objection would be, my lord, the domain of the competent legislature. When the subject is in the concurrent list, we cannot rule out the possibility of one state agreeing to it, another state legislating in favor of, another state legislative against it. So therefore, in absence of the states being not joined, my lord, the petition would not be maintainable. That's one of my preliminary objection. Lord, as I mentioned yesterday, Lord, I have also filed an application, my lord, requesting they decide a question which I have formulated as a preliminary question, my lord, essentially for this reason. A, Lord, the notices were issued in January, my lord. We didn't have an occasion, my lord, thereafter matter was never heard in merits, to raise the preliminary objection whether this court can at all go into this question, or it would be essentially for the parliament, my lord, to go into that question. Second, my lord, we also, my lord, would like to point out what would be the repercussions, my lord, if the court were to take it upon itself, my lord, in the judicial forum to take this call. The sum and substance of my application would be, if I were to say in one line, the debate which is to happen with respect to the subject matter of creating, conferring a sanctity, legal recognition of a socio-legal institution, should that be the forum of this honorable court or the forum of the forum of the parliament?
Mr. Solicitor, two responses to that.
Lord, may I...
Just 1 second, Mr. Ragbi. The nature of your preliminary objection and the tenability of your preliminary objection will really depend upon the canvas which they open up. And we say that with a due amount of reflection of mind on this. Let us see what is the canvas that they are opening up. Second, so that then we can consider your response. Second, what is really in the nature of a preliminary objection that you seek to raise is really your response to the petition on merit.
No, my lord.
So we'll hear you on that.
Lord, I'm
we will
sorry,
certainly,
my lordships may not preempt, my lord, my submissions on merit.
We'll hear you, of course. I mean, it can't be lost to our mind that what you're going to argue is that
I'm obliged, my lord, your lordship
domain of
will hear me, my lord.
That it's essentially in the domain
Kindly
of
allow me to
Parliament.
clarify.
Court should
Kindly
not enter into it.
allow.
So we'll hear you on that at a subsequent stage when you are responding to the arguments. Second, once we have some picture in the first 15 minutes or maybe half an hour on what is the canvas they are arguing, we may have a response to them on what is the canvas that we want to open up in this matter. But that's after we hear them, because
Lord, may I say, let me make my submission.
To tell them that, well, this is what we want to be, which we want to go into, would be really to preempt their submissions on what they want us to go into it. For in all probability, for instance, they may say that this is so far and no further.
Personal law, there are also issues of personal law, adoption, succession, several issues that arise out of this. And that's the canvas that your lordship should be looking at.
Only one more thing. I'm after my lord, Mr. Sibyl comes.
This is the canvas. We want to view how it is being opened up.
Yes.
And whether it's the whole canvas to be opened up, not to be.
That's correct. That's.
Yeah, they're not that we are not.
No, your lordship. I'm just one of the caveat that I'm just putting.
You're right. Yes, you're right.
There are other very complex issues. Whether your lordships would like to go into that, not go into that. Once we know, then we'll be able to address your lordship.
That's exactly what we thought we'll. That's
Can I conclude, my lord? Can I complete my request?
Yeah.
My lord, I'm sorry, my lord, my lords. Slightly, my lord, preempted my request. First of all, I'm making it very clear. My preliminary my lord, objections are not my objections on the merits. If merits were to be gone into, there are separate set of arguments. These are not, my lord, these are only for deciding which forum would adjudicate upon and which forum would be the suitable forum and constitutionally the only permissible forum where this debate can take place. So by the very nature of the objection, it must, in my respectful submission, be heard first. While arguing my preliminary objection, I'll not raise any submissions on the merits of the case. I'm, my lord, very, very clear about it. And, my lord, therefore, my lord, your
So,
lordship,
Mr. Solicitor, we'll reserve, whether to hear you on the preliminary objection at this stage after they have opened up, just for about 15 to 20
my lord,
minutes. So that then we can
then your lordships may do one thing, my lord. That's the another request. My lord, let them give, my lord, their, my lord, suggest whatever submissions they want, overview, confined to, my lord, what my preliminary objection is. My lord, I can't be
we will
non-suit.
certainly
Lord,
not. We'll not do
I have to
anything.
open my case.
My lord, I'm sorry, my lord. My lord, I'm sorry.
I'm sorry, Mr. Solicitor. We are in charge. We will hear Mr.
I have
I'm
to
sorry,
open
my lord.
my
Kindly
case.
last minute, my lord, last.
Mr. Solicitor, we'll hear you later.
Yes.
Yes, Mr.
My
Roy.
lord, only a minute, my lord, only a minute.
No.
My lord, your lordships may give me a minute.
Dictate to us how we will conduct the proceedings.
No, I'm not, my lord. I am
I'm not
earnestly
allowed that
requesting.
in my court.
My lord, I am earnestly requesting. I would never do that. Your lordship knows, my lord.
Yes.
My lord, this is a matter, my lord, too sensitive an issue,
Of course,
where, my lord,
yeah.
your lordships would examine the preliminary submissions and, my lord, then give me some time. We may have to consider what would be the stand of the government, my
Certainly.
lord, in further participation in this debate.
So trust us to have a broader perspective of everything.
Well, I fully trust, my lord. There is no question
Therefore,
of
we are
lack
just-
of trust.
We want to understand from them what they want to argue.
My lord, then, my lord, your lordships may give me time, my lord, to consider to what extent the government would like to participate in this.
Anything but adjournment, and I think anything but an adjournment.
No, I understand, my lord, your lordship's anxiety, my lord, I understand. I share that.
So, are you saying that you don't want to participate? No,
Lord,
Very
my lord,
strange
I am
phrase.
only
To
saying,
participate, it's a prerogative you have.
my lord, I'll
But
not go
you
that far, my
cannot-
lord.
No, Mr. Solicitor, that, let me say that. They look nice. When you say that we will see whether we participate or not.
No, my lord, I'll take instructions. I didn't say I'll not participate.
Instructions are here with this constitution.
My lord, the instructions on the question whether which forum should debate and discuss this subject.
That's a very important situation itself. That's the main this thing, whether the court can go into it or whether only parliament will legislation issue like this.
Lord, your lordships would examine, Lord, kindly give me 2 more minutes. Lord, this is not an issue which can be debated, Lord, by 5 individuals very learned on that side, 5 individuals on this side, 5 very brilliant minds on the court, no doubt about it. None of us knows what are the views of, my lord, a farmer in South India, a businessman in, my lord, Northeast. Lord, these will have to be, my lord, this will have social and other ramifications, my lord.
Yes, of course. We'll consider that. We'll certainly have that in
My lord,
mind.
your lordships, I'm sure would consider the request. Only request is kindly consider that first.
No, we'll allow them to open the case so that we have
My lord,
an
then your
idea on
lordships
what they
may,
are.
my lord, rule on that. That's my prayer, my lord.
May
That's
I
my
submit,
prayer.
my lord?
Yes.
A short preface first.
Statement of state, my lord, on behalf of state of Madhya Pradesh, which your lordship was kind enough to direct it.
Sir, we'll hear you. There's no
Not
difference.
Your
for
lordship may hear any
intervention, my lord.
state. We have no objection. Your lordship may hear any state.
No, not
Just as a
intervention, I'm
preface,
No, you should have
everything which
joined
the
every
solicitor
state
has
as a.
said does not, my lord, hinge on maintainability of a petition under 32 by an individual who complains that his fundamental rights are being restricted in some form. I have a right to approach this court. This will be a defense, whether your lordship will leave it to the legislative forum or the court's forum. There is no question of saying, my lord, that I should answer that first. I will open my case. They will raise a defense. Please don't touch it. Throw it away. Your lordship do it all the time. Matter of executive policy, we won't touch it. He will say whatever he has to say. But I have a right to file a 32. I have a right to be heard. My grievance may be right, may be wrong. Your lordship will deal with it. And your lordship will deal with their responses about, my lord, this, that, or the other when it comes. It's not a case of 7-11. That, my lord, a suit is barred by operation of law. That is a preliminary objection. This can't be a preliminary objection that your 32 is there, but the impact of 32 will be this or that.
No, it's
That
maintainability
impact can
is
never
a
be a part,
preliminary
Lord,
objection.
of a preliminary objection. That be a defense. That don't touch it. This is too overbroad. This, that. They will say all that, my lord. So now, my lord, let me open my case.
Yes.
Well, only one aspect, my lord, and my
Please
lord,
now.
Yes.
ultimately
Allow
it's
us
the
to
lordship's prerogative. But I should not, my lord, be, my lord, told after, my lord, generations after generation, we did not bring this to a lordship's notice. In Special Marriage Act as well as in Hindu Marriage Act, every state have separate rules.
Please.
That makes more, my lord, case for calling all the states and hearing them. Your lordships have, my lord, partial view from both sides.
Only one
He is very clear about his view. I may be very clear about my view. but none of us represents views of the nation.
My Lord,
That's my preliminary
Your-
objective.
My Lord, the Solicitor General is aware of all the persons that we are talking of fundamental rights. Fundamental rights, by their very nature, are a limitation on the legislative power of the state. Your Lordship need not defer to
I'm
Parliament.
not for a
it's
second
now-
saying
If it is a fundamental
is
right,
not
my Lord,
there.
and if it
Who
is,
should protect the fundamental
it is
right?
a
Whether by
status-
parliamentary law?
All right, what
Lord,
we
Can
do
I-
is,
can I- let us
fair
start,
enough.
let's-
my Lord, if it is a status confined to,
We'd like
Let
to
me
just-
open my-
Yes, you can tell us.
Yes,
about
let me
15
open my-
What is the canvas of the?
Of course, my Lord, subject to my first respectful submission about the maintainability. But, my Lord, just I'm assisting your Lordships on this. My Lord, this comes after your Lordship's judgment of 2017, my Lord, the Johar judgment. Lord, please see, my Lord, so that my learned friend rest assured, page 34. Your Lordships have that, my Lord, my application.
The act actually. You've got the
Act, your Lordships have the act, my Lord. Kindly see section 2. I'll not read all sections, my Lord, some of the sections. Appropriate governments, your Lordship can skip. Establishment, defined. Family, defined. Inclusive education, defined. Institution, defined. Please come to 2K. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and includes trans man or trans woman within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy and such other therapy, bracket over, persons with intersex variations, gender queer, and person having such socio-cultural identities as so and so, so and so, so and so. Correct, my lords? Your lordships concern freedom of choosing sexual orientation. No objection, my lord, cannot have any objection. That's my lord's judgment. Freedom of privacy, no objection, act take care. Discrimination, there cannot be, the act takes care. I'll, my lord, show to your lordships. The limited question is conferment of a socio-legal status and whether that can be done by judicial adjudication, and I'll come to special marriage act. Lord, now please see prohibition against discrimination. Lord, all arguments that we are not getting this, we are not getting treatment, we are not getting, Lord, please see this. No person or establishment shall discriminate against transgender person on any of the following grounds, namely the denial or discontinuation of unfair treatment in educational establishments and services thereof. And transgender here means LGBTQ plus, not, my lord, transgender as we colloquially or, my lord, conventionally understand. The unfair treatment in or in relation to employment or occupation, the denial of or termination from employment or occupation, the denial or discontinuation of unfair treatment in healthcare services, the denial or discontinuation of or unfair treatment with regard to access to or provisions of enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or appropriate or opportunity dedicated to the use of general public or customary available to the public, denial or discontinuation of unfair treatment with regard to right of movement, denial or so and so unfair treatment with regard to right to reside, purchase, rent, or otherwise occupy any property. These are all criminal offenses if there is a denial. Denial of access to removal from unfair treatment in government or private establishment in whose care or custody a transgender person is, then recognition of identity of transgender persons. Recognition of a transgender person shall have a right to be recognized as such in accordance with the provisions of this act. Right to dignity, right to personhood, as my lord, the Chief Justice said. A person recognized as transgender under subsection 1 shall have a right to self-perceived gender identity. Application for certificate of identity. My lord, statutory certification is given that you are falling within the definition of transgender under 2K, based upon which you exercise your rights. And if there is any violation, there are penal provisions. Then issue of certificate, change in gender, my lord, even if, my lord, in LGBTQ, there are changes which take place, my lord, because of hormonal therapy, other therapies, operation, etc. My lord, there is a concept of fluid gender. Sometimes a person is male, for few days he is female, etc., etc. Let's not go into it. That's on the marriage, and we have much to say on that. Change in gender. After the issue of certificate under subsection 1 of section 6, if a transgender person undergoes surgery to change gender, either as a male or female, such person may make an application, then he gets a new certificate. Obligation of the appropriate government. There are statutory obligations, either central government or the state government, as the case may be, to take steps to secure full and effective participation of transgender persons and their inclusion in the society. The appropriate government shall take such welfare measures as may be prescribed to protect the rights and interests of transgender persons and facilitate their access to welfare schemes framed by that government. Appropriate government shall formulate welfare schemes and programs which are transgender sensitive, non-stigmatizing and non-discriminatory. Appropriate government shall take steps for the rescue, protection and rehabilitation of transgender persons, etc., etc. Then, my lord, obligations of establishments and other persons. Lord, there is a provision for a reservation for transgender persons. It's not, my lord, right now nobody is arguing the question of dignity, respect, privacy, etc. Right to choose one's sexual orientation. The definition is widely worded. Any deviation from the normal sexual orientation is protected under 2K. And, my lord, rights are given, and any discrimination is criminally prosecutable. Right now, the limited question is, can by a judicial adjudication process, this honorable court create a institution of marriage for the simple reason, Lord, whether we like it or not, whether they give it up or not, whether, my lord, your court would go into it or not, it necessarily affects personal laws. Lord, Hindu Marriage Act is a codified personal law. Islam has their own personal law. Part of it is not codified. Hindu law also, part of it is not.
Into it, Solicitor, we said
Only a minute.
to them that so far as personal laws are concerned, we are not at present getting into that arena at all.
That's not the point. Somebody who is Hindu, who is not here, can come and say that, why did you not give me the same treatment? I want to be Hindu. I want to marry under the Hindu Marriage Act. And if you give benefit...
But we are not getting into it. Why?
Getting into it. So then where is
your lordship will have to. Right now, your lordship don't have that argument.
We, of
There's
course
no compulsion.
not.
We must get
Only a minute. Like, can I?
You don't have to decide the broader in order to decide the much more restricted
That's what he
arena.
said.
Another aspect. And which I... that confining the remits, my lord, I have something to say, my lord. Lord, your lordships would have Hindus, Muslims, everyone, whether your lordships go into or not, everyone will be affected, and therefore the central government very respectfully but specifically, my lord, prays that states will have to be heard.
How many times will you
That's
say
the
the same
question
thing?
we are trying to pose, Solicitor. If we are not touching the person, it's like saying that you must touch personal law. We don't want to touch personal law. We don't want to touch personal law, then why state should be heard? We are confining our remit at the moment only to one issue. So for that issue, whatever has to be heard is only for that issue, which is
Marriage...
under the special... Completed, then you may answer. Under the Special Marriage Act, can we read it in a manner that it is a person? That's all. We are saying we are not going into it. So why should there be a compulsion of the court? You must go into it.
So, Solicitor,
That's
can you
it.
give an example of what you're trying to argue? Because if the remit is being defined in this manner, how do you say that this has some other reference?
Yes.
If you are
Lord,
that's
one Mr. A, he is Hindu. He wants to continue as a Hindu. He wants to get married under the Hindu Marriage Act. He wants to undergo the...
We're not going to address that at all.
We are not rejecting or accepting. We are saying we are not doing it at the
Lord,
moment.
we are then begging the question, my lord,
Maybe.
to reach somewhere. We are, my lord, short-circuiting the issue, my lord. That's Kindly allow me. Kindly let me. Lord, I am for the first time begging that I may be heard.
To create something
be
which we're
heard,
not
not
doing, and then you say
I'm
you
just
can't.
I am obliged.
understand what is that you are saying. We are saying we have confined them. They may have opened a very wide chapter. We said no, we don't want to get into that wide area. We don't. Today we are only deciding this A issue. We are not touching other issue. Nobody is being prejudiced because we are neither rejecting it nor accepting it. Then we can't be compelled to hear everything else.
No,
at this
nobody
stage.
is compelling, my lord. At least on our side, we are saying your lordship should not hear.
No,
We are not
you are
compelling.
saying, but you are saying don't hear this alone. Hear everything, or hear.
No, I am saying don't hear it, my lord. I am
You're
not.
saying don't hear it at
I am
all.
saying let the parliament hear it, my lord.
That's right. But therefore, we are trying to steer a middle course, which is that we don't want to
Lord,
first say that, well, we will decide
Lord,
everything,
when we are
and
deciding
then be
fate of,
confronted with this argument.
Is opening, but
it has several windows have opened.
the window will have to open the entire door. So don't do it.
I would, my lord, kindly on the lighter side and don't take otherwise. Several windows have already opened. Now they are trying to open the door, and I am saying that you will have to ultimately open your entire house.
Mr.
As an
Solicitor,
example, the question is whether those
He is relying on those windows which have opened.
windows have got sufficient breeze inside or not is the question.
Now,
And-
another aspect.
and those windows are willy-nilly going to open whatever we decide, because society is not dependent on.
Lord, I
on
must, my
legal
lord, say as a
arguments.
citizen.
Windows have opened up.
No, no, my lord. I'm saying as a citizen. I'm not saying yes or no. Societal relations, acceptance of any relationship in the society is never dependent either on legislation or on judgments. It comes only from within. Let us accept it, whether we like to accept it or not. But leave it at that. That's, my lord, more on my lord, other philosophical aspects. Your lordships are persuaded to take up Special Marriage Act, possibly, my lord, on the ground that in one of the section the word used is spouse. Lord, my respectful submission is this, and kindly, a person, Lord, not a spouse. My lord, my respectful submission is this, and kindly, my lord, examine this correctly, a little, my lord, closely. Even Special Marriage Act, and I will show, my lord, if I have to, my lord, at the subsequent stage. The legislative intent of the legislature throughout has been a relationship between a biological male and a biological female, including Special Marriage Act.
But Mr. Solicitor,
Number one,
there's a very important value judgment which you are making, that the very notion of a biological man is absolute, or that a notion of a biological woman is also an absolute notion,
Never change.
which is incorrect.
The only
No.
biological man means biological man. It's not a question of notion.
Positives of rights.
Yes, of course it is.
None of us.
There is no absolute concept of a man or an absolute concept of a woman at all. That's the
Lord,
whole
I am-
argument in a broader
Lord,
constitution.
biological man, my lord, means man only. It means, my lord, biological man. It's
Biological
not a
man is
matter
not a
of
definition
notion.
of what your genitals are. It's far more complex. That's the point.
We stop having rights if we are not a biological.
So even when the Special Marriage Act says man and woman, the very notion of a man and a notion of a woman is not an absolute, based on what genitals you have.
Lord, biological man means genitals you have. Lord, I didn't want to use that expression.
That's a point of view.
Lord, another thing, for man, irrespective of other attributes than the genitals, there are separate age limits prescribed. Lord, what are we doing?
No,
That's not an argument. That's not an argument.
Or we said it is not a mandatory thing that the whole society must accept something. Changes have always come in.
But your lordships will have to examine whether marriage is a fundamental right. Right to marry, divorce the law is a fundamental.
That's what I want to establish, no?
Lord, only a minute.
What
Only a
else we
minute.
want to
Lord,
establish?
only a minute.
Seeking to confine.
Lord, I know my difficulties. Lord. I know my difficulties, but I am still discharging my duty. Lord, there are several acts. If the notion is treated to be a guiding factor to decide man or a woman, then I will show several acts which your lordships would unintentionally make non-workable. I may have, my lord, genital of a man, but if I am otherwise a female, my lord, as my lord possibly trying to be suggested, then, my lord, how would I be treated under the criminal procedure code? As a woman, my lord, can I be called? For 160 statement after a particular hour, I may say that this is only a notion. I may have a biological genitals of a man, but now I am a woman. Well, there are several issues, my lord, which have to be gone into. Better they go into be gone into by the parliament. And your lordships, my lord, kindly appreciate. But the parliament, we have good eminent parliamentarians on both sides, and I can say this based only on my reading. My lord, parliamentary committees are not, my lord, acting the way in which, my lord, we see parliaments functioning. Parliament committees have all parties as members.
The lighter side, they say that real work is done in the parliamentary subcommittee.
Yes, yes. My lord, they call witnesses, they call expert witnesses, they call stakeholders, they decide.
We have both Justice Kaul and I, we have engaged with the department-related parliamentary committee. I chair the E-committee, Justice Kaul chairs NALSA. We have engaged extensively with the parliamentary committee. In fact, part of the reasons why we have this huge support now for the E-committee is because of the
I know, I'm aware of.
support
In a different capacity, I'm aware.
But see,
No, my lord, it's not that, my lord. There are certain issues, my lord, which are better left to the discretion of the parliament. Your lordship's, my lord, concern, the government shares. No discrimination, no breach of privacy, right of choosing one sexual, my lord, orientation. Everything is taken care of.
Mr. Solicitor, you are underestimating the impact which your argument is having on us. Don't underestimate the impact which your submissions are having on us. And now it's our turn now to put those problems to Mr. Rohit when he
Another aspect, my lord, another aspect.
We know where we are trying to find. We are also
I'm fully confident. I'm fully confident. I'm fully confident. Only a minute more. Only a minute more.
Let me continue. I'm only saying they came with a broader canvas, much broader canvas. We are saying we are unwilling to go into the broader canvas. We are not willing to go into the broader cost. We are not willing to go into personal laws issues. We are not willing to go into ABCD. Therefore, they have agreed to, for the time being, confine it only to the aspect which we are willing to rule on. And it cannot be said we must rule on everything. We are only willing to rule on that aspect. If that is the only remit which we are willing to consider, then naturally their arguments or your arguments, you may have arguments whether it can be done under this act or not, whether even what is being sought to be canvassed by them should be left to the legislature to consider whether they would like to get into it. But the remit or the contours of the argument will thus have to be restricted only to the extent we are willing to consider the issue. It can't go beyond.
I'll just give an example why I'm saying this. I'm just giving an example.
And it is still open to you to argue in response that don't go into even this limited remit. That is again.
I'm obliged. I'm obliged. What has happened is this. In Navtej Johar, when the limited question was decriminalization of section 3 X mentioned in 377, the central government very carefully filed an affidavit that we leave it to the wisdom of the court. We are not, but there we did say in no uncertain terms and recorded by your lordships that this is not an issue where we were even remotely touching about other issues of marriage, etc., etc. But as my lords have said, the window of marriage did open there. Now, today your lordships may not go into the question of personal laws, but the window of that personal law will open. Lord, ultimately, your lordships are dealing with her.
Solicitor, we cannot ever bind future generations after we are gone.
Exactly my submission.
These are dusted and done.
Lord, that's the
task for the future generations.
Lord, that's from
whether it's the legislature or the court. I mean, we leave it open to
Lord, that's my
generations to run the country with the sense of
I'm not saying your lordships would bind. Your lordship would never bind. That's the majesty of the court. But your lordship's not going it right now and giving some considering giving some relief would not mean that your lordships have never gone. That would, my lord, open another. That's all okay, my lord. That's okay. But ultimately, my lord, your lordship will have to consider this. Even Special Marriage Act does not prohibit, and entry 5 concurrent list is agnostic. It's not on personal law. It's a law of marriage. It's not Hindu marriage, Parsi marriage, or Muslim marriage. It's a law of marriage. It's their right to legalize, not to legalize, provide for many things, etc., etc. And therefore, my lord, again, I am reiterating that my preliminary application, and there is a reason why I am repeatedly reiterating, my preliminary objection be taken up first, and your lordships may issue notice, my lord, to all the states. I am reiterating that request with a purpose, my lord, with an intent.
All right, we'll reflect on it at lunch and we'll take a call.